This is Chapter 7, Extinguishment of Sales on the Book of Law of Sales, which will discuss about the causes of termination of a contract of sale, such as conventional redemption and legal redemption. According to Article 1600, the causes of extinguishment can be divided into three. First are the common causes, which are the same causes and obligations, such as payment or performance and loss of a thing due. Second are the special causes, which are recognized by the law on sales, which will be mentioned in the preceding articles. And third are the extra special causes, which are conventional redemption and legal redemption. We will first talk about conventional redemption. According to Article 1601, conventional redemption shall take place when the vendor reserves the right to repurchase the things sold, with the obligations to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon. Sales with the right to repurchase are also commonly called acto directo sales. The things to note in conventional redemption are: the seller must have expressly reserved the right in the contract, the seller must return the purchase price and reimburse the buyer for the necessary expense. The redemption period cannot exceed 10 years. If no period is specified, the seller has 4 years to redeem. If the redemption period is not executed on time, the sale becomes absolute, permanently transferring ownership to the buyer. We will now proceed with equitable mortgages. Under Article 1602, the following cases indicate that a contract is presumed to be an equitable mortgage: when the price of a sale with the right to repurchase is unusually inadequate, when the vendor remains in possession as lessee or otherwise, when upon or after the expiration of the right to repurchase, another instrument extending the period of redemption or granting a new period is executed, when the purchaser retains for himself a part of the purchase price, when the vendor binds himself to pay the taxes on the things sold, or in any cases where it may be fairly inferred the real intentions of the parties is that the transaction shall secure the payment of debt or the performance of any other obligation. In any of the foregoing cases, any money, fruit, or other benefits received by the vendee as rent or otherwise shall be considered as interest, which will be subject to the usury laws. To further understand, let's take a look at the illustration. Anna, struggling with financial difficulties, needs 500,000 pesos to cover urgent medical expenses. She approaches Ben, a wealthy businessman, who agrees to lend her the money, but instead of a loan contract, he insists on executing a deed of sale for Anna's house, stating that she is selling the property to him for 500,000 pesos. However, the agreement includes the right to repurchase, allowing Anna to buy the property within 2 years for the same amount. Despite the supposed sale, Anna continues living in the house, pays the real property taxes, and even executes another document extending the redemption period beyond 2 years. The illustration shows the cases number 1, 2, 3, and 5 discussed in Article 1602. It also shows that acto directo sale is used as a way to circumvent the formal foreclosure of a mortgage and as a way to get cash in a quick manner due to the desperation of the seller. As a countermeasure, under Article 1603, in cases of uncertainties in contracts with the right to repurchase, it is generally presumed to be an equitable mortgage.
So good day everyone. Today I'll briefly explain Article 1604 of the Civil Code. The provisions of Article 1602 shall also apply to a contract purporting to be an absolute sale. Article 1604 states that even if a contract appears to be an absolute sale, if there is doubt as to its real nature, it shall be presumed to be an equitable mortgage, especially when any of the circumstance under Article 1602 is present. This means the law leans toward protecting the seller by treating the transaction as a loan secured by mortgage rather than as a true sale. This is because pacto de retro sales, or sales with the right to repurchase, are generally disfavored by the courts due to their harsh effects. If a contract is ambiguous, courts look beyond the title and wording and will allow parole evidence or verbal and external proof to uncover the true intent. So, take a look at the example. Imagine Maria was in desperate need of money. She sold her land to Juan for 100,000 with a promise that she could buy it back within 6 months. Juan got the sale transferred to his name. However, Maria never intended to sell. It was really a loan, and her land was meant to be the collateral. 6 months passed, and Juan refused to let her redeem it. Maria goes to court because of the presence of one key indicator of Article 1602, that the price was grossly inadequate, and because Maria stayed on the property and continued paying real property tax, the court rules the sale was actually an equitable mortgage. Thus, one must go through foreclosure, not automatically become owner. Article 1604 ensures fairness, protecting vulnerable sellers from losing their property unfairly by recognizing when a sale is really a disguised loan. So let's explain Article 1605 of the Civil Code. In the cases referred to in Article 1602 and 1604, the apparent vendor may ask for the reformation of the instrument. Article 1605 provides that in cases covered by Article 1602 and 1604, where a sale may actually be an equitable mortgage, the apparent vendor may ask for the reformation of the instrument. Reformation is a legal remedy where a written document is corrected to reflect the true agreement of the parties. It allows when the parties had a meeting of minds, but due to mistake, fraud, or accident, the contract's written terms do not reflect what they really agreed upon. Here's an example. Sofia borrows 200,000 from Carlo and gives her land as security. They both intend to be a mortgage, but the written contract says Sofia sold the land to Carlo with the right to repurchase. Since the document doesn't reflect their real intention, Sofia can go to court and ask for reformation to correct the contract so it shows a mortgage, not a sale. But take note, if there was no real agreement, like if Sofia thought it was a loan, but Carlo thought it was a true sale, then reformation is not the remedy. The correct remedy in that case is annulment, because there was no meeting of the minds. So Article 1605 protects parties when a written contract does not express their real agreement. It ensures that the true intent, whether it's a loan secured by mortgage and not a sale, it is honored by the court. Article 1606. The right referred to in Article 1601, in the absence of an express agreement, shall last 4 years from the date of the contract. These articles refers to the right of repurchase in a pacto de retro sale, a kind of sale where the seller, vendor a retro, has the right to buy back the property from the buyer vendi eretro within a certain period. Default period. If there is no express agreement about the period to repurchase, the law automatically sets it at 4 years from the date of the contract. Maximum period. Even there is an agreement, the maximum allowable period is 10 years. If a court later decides that the contract has indeed a sale with right to repurchase, the seller is still given 30 days from the final judgment to exercise that right, even if the usual period was expired. Example number 1, no agreement. Juan sells his land to Pedro on January 1, 2020, with a right to repurchase, but no period is mentioned in that contract. According to Article 1606, Juan has until January 1, 2024 to repurchase the land. After his date, if Juan doesn't repurchase, Pedro becomes the full owner. So, for example number 2, with agreement. Maria sells her house to Ina on June 15, 2021, and the contract says she can repurchase it within 8 years. This is valid because the period is stated and it does not exceed 10 years. So Maria has until June 15, 2029 to repurchase the house. Example number 3 with court judgment. Luis sells land to Carla under a contract that looks like a mortgage, but Carla claims it's a sale but with right to purchase. Luis files a case saying it's just a loan with a mortgage. The court later rules that it was indeed a pacto de retro sale. Even if the 4 to 10 years have passed, Luis still has 30 days from the final judgment to repurchase the land. Let's explore Article 1607. In case of real property, the consolidation of ownership and the vendee by virtue of the failure to the vendor to comply with the provision of Article 1616 shall not be recorded in the Registry of Property without a judicial order, after the vendor has been duly heard. Article 1607 covers the consolidation of ownership in a sale with the right to repurchase, or pacto de retro. It is a provision that protects both parties involved in such a sale when the vendor fails to redeem the property. Under this article, when the vendor doesn't redeem the property within the agreed period, the vendee or the buyer becomes the owner of the property. However, this ownership consolidation can be recorded in the Registry of Property without a court order. The vendor must be given the opportunity to be heard in court first. This extra step is essential because it ensures that the sale is genuine. Sometimes a transaction might look like a sale, but it is actually equitable mortgage, where the property was sold only was as a collateral. For example, let's say Juan sells his land to Maria under a pacto de retro, where Juan has the right to repurchase it within a year. After 1 year, Juan fails to redeem the property, so Maria automatically becomes the owner. However, before Maria's ownership can be recorded in the property registry, Juan must be heard in court. If Juan claims it was not a sale but a mortgage, the court will determine if Maria's ownership is valid.
Article 1608. The vendor may bring his action against every possessor whose right is derived from the vendee, even if in the second contract no mention should have been made of the right to repurchase, without prejudice to the provisions of the mortgage law and the land registration law with respect to the third persons. So this article talks about the vendor's or the seller's right to redeem a property that he sold with the right to repurchase or back to direct resale. So if a seller includes in the sale a right to repurchase the property, he can get the property back from whoever owns it later, even if it has already been sold to someone else, as long as the new buyer got the property from the original buyer or the vendee. So this is true even if the resale contract didn't mention the seller's right to redeem. However, this is subject to laws on mortgage and land restriction, especially when dealing with third parties who may not be aware of the seller's right. So there is two nature of the right to redeem. The first one, it is a right and not an obligation. The seller has the option to redeem. It is not a duty. The right can be exercised even if there was no immediate payment or deposit. The important part is that the seller must actually pay or offer to repay the price when redeeming, as clarified in the case of Immaculate versus Navarro. The second one is a real right, not just a personal right. This means that the right follows the property, not just the person. The seller can enforce the right even against a new owner who bought it from the buyer. However, there is an exception for this. So if the land was registered and the right wasn't noted, especially under the torrent system, then a buyer in good faith may not be bound by the redemption right. So, for example, S sells a piece of land not registered to B with a right to repurchase. Later, B sells the land to C, who buys it in good faith without knowing about S' right. Even though the contract between B and C did not mention the right to repurchase, S can still redeem the land from C because the land is not registered and C's right comes from B. So if the land is registered under the torrent system and S right to redeem is not written on the land title, then C, who is a buyer in good faith, got the land properly registered, does not have the owner S right to redeem. Article 1609, the vendee is subrogated to the vendor's rights and actions. So there is an rights acquired by vendee retro. First, vendee is subrogated to the vendor's right. So the buyer gets all the rights the seller had over the property, except for the full ownership if the property is subject to repurchase. For example, if A sells the land to B with a right to repurchase, B can lease the land or mortgage it. But if A later redeems the land on time, B must give it back to A. Second, right to eject the vendor. So if the seller or vendor retro doesn't redeem the property on time and refuses to leave, the buyer or the vendee retro can ask the court to remove the seller from the property. Take note that the buyer doesn't need to prove that they had possession before, as long as the seller didn't redeem the property and the buyer has title, the buyer has the right to recover the possession. For example, A sells land to B with a right to repurchase in 1 year. If A fails to redeem it and won't leave, B can now lawfully evict A. Article 1610, the creditors of the vendor cannot make use of the right of redemption against the vendee until after they have exhausted the property of the vendor. If someone or the vendor owes money, the creditors can't use the vendor's right to redeem a property from the buyer unless all other properties of the vendor have already been used to pay the debts. However, there is an exception. If a creditor has a mortgage or lien on the property before the sale, they don't need to wait. They can foreclose or claim the property directly. For example, A owes money to S, then A sold land to B with the right to repurchase in 1 year. A still owns other cars, bank accounts, and a business. So, X cannot use A's right to redeem the land unless All of A's other property were already used to pay debts but still not enough. Article 1611, in a sale with the right to repurchase the vendee of a part of an undivided immovable who acquires the holder of, in the case of Article 498, may compel the vendor to redeem the whole property if the latter wishes to make use of the right of redemption. So if the vendee buys part of undivided property but wants to repurchase, they have special rights. They can force the original seller or the vendor to buy back the entire property if the vendee wants to use the right to repurchase. So this article aims to discourage co-ownership of property as it often leads to conflicts and does not promote the improvement of the property. There is a redemption in sale of part of undivided immovable. First, partition demand. A co-owner can request to split the property based on their share. If the property can't be divided fairly, the entire property may be sold and the money will be shared. Second, rights on repurchased property. If a person buys an entire undivided property but part of it is subject to repurchase, they can ask the vendor to buy back the whole property to avoid co-ownership issues. So, for example, A, B, and C are co-owners of an undivided parcel of land. A sold this undivided portion to D with the right to repurchase. As a result of a partition, D, who is now one of the co-owners, acquired the whole land after paying the portions belonging to B and C. If A would like to repurchase the portion that he sold, D has the right to require A to repurchase the entire land or the whole land to avoid co-ownership issues.
Article 1612. If several persons jointly and in the same contract should sell an undivided immovable property with a right of repurchase, none of them may exercise this right for more than his respective share. The same rule shall apply if the person who sold an immovable alone has left several heirs, in which case each of the latter may only redeem the part with which he may have acquired. This article means that if several persons together as co-owners or co-heirs sell an undivided property with a right of repurchase, Article 1612 says each seller can only repurchase the portion that corresponds to his ownership share. No one person may use the repurchase right to recover more than what he originally owned. The same rule shall apply if a single owner or seller dies and leaves the property to several heirs. Each heir can only redeem the portion or the part that he inherited. So, for example, A, B, and C owns piece of land equally, each of 1/3. And they jointly sell it to D with a right of repurchase. If A later wants to repurchase, Article 1612 limits him to just his 1/3 portion. Even if he pays for the whole price himself, he cannot claim that other 2/3 portion by B or C. Likewise, if their mother X had died and they inherited the land, each of them can only recover the 1/3 they inherited. Article 1613. In the case of the preceding article, the vendee may demand of all the vendor or co-heirs that they come to an agreement upon the repurchase of the whole thing sold. And should they fail to do so, the vendee cannot be compelled to consent to a partial redemption. This article gives the buyer a vendee a retro. It is a protection in a joint sale. It says that in the situation of Article 1612, the buyer can insist that all the co-seller or co-heirs agrees on repurchasing the whole property. If the sellers cannot agree to redeem the entire land together, the buyer is not required to accept this partial redemption. So example, let's use the example of Article 1612. So let's say that A, B, and C own the land and then they jointly sell it to D. Now, if later A wants to buy back his 1/3 portion, D is under no obligation to repurchase D is under no obligation to accept this partial offer as stated in the Article 1613. Article 1614. Each one of the co-owners of an undivided immovable who may have sold his share separately may independently exercise the right of repurchase as regards his own share, and the vendor cannot compel him to redeem the whole property. Article 1614 deals with the opposite case naman, that what if the co-owner sell his own share but separately, so hindi na siya jointly, and still with a repurchase clause. So in that case, each seller may independently repurchase his own portion, and the buyer cannot force any one of them to redeem more than that portion. In other words, when sales are separate, each co-owners or co-vendor stand on his own repurchase contract for his own share. So, example, let's give one example to better understand this. Suppose again that A, B, and C still own 1/3 of that land. But this time, A sells 1/3 to D, B sells 1/3 to D or another buyer, and C sells 1/3 to D then and another buyer then. So D does likewise. But it all separate, all separate deeds, all separate contract, papers, etc. With report and still with that repurchase right. Now, if A want to exercise his right, he deals only with the contract he made. By Article 1614, A can purchase just his 1/3 of the land from D on his own terms. And D cannot force A to redeem B's or C's portion. Likewise, B and C independently buy back their own share if they choose. Each seller situation is treated independently because the sales were separate. Article 1615. If the vendee should leave several heirs, the action for redemption cannot be brought against each of them, except for his own share, whether the thing undivided or it has been partitioned among them. But if the inheritance has been divided and the thing sold has been awarded to one of the heirs, the action for redemption may be instituted against him for the whole. So, Article 1615 naman protects both the vendors and the buyer's heirs. It provides that if the buyer or the vendee dies leaving several heirs, a redemption action by the original seller or vendor a retro can be brought only against each heir for their heir's share. In other words, the vendor can claim from each heir only the fraction of the property that they inherited. However, there is an exception. If the inheritance has been divided and one heir is awarded the entire thing that was sold, then the vendor may redeem the whole property from that one heir. So let's give an example to this. So A pa rin, same example pa rin. So A sold land to B and still with a right of repurchase. And then B dies, leaving 3 children as his heirs. So let's say his children are C, D, and E. So by Article 1615, if A wants to redeem or exercise his right of repurchase, he must approach each heir separately for their portion. So each heir owns a one-third. So A can redeem to one-third from C, and he can redeem one-third from D, and redeem one-third from E. However, if a court of partition awards the entire land to say, let's say, E, then A can redeem the whole land or the whole property from E, from E alone. In that situation, E essentially stand as B's sole successor for that property or that land.
Now let's discuss the Article 1616. So, Article 1616, which have been mentioned at multiple times earlier, this is about the obligation of the vendor who desires to exercise his right of repurchase. So, Article 1616 or 1616, the vendor cannot avail himself of the right of repurchase without returning to the vendee the right price of the sale, and in addition, the expenses of the contract and any other legitimate payments made by reason of the same. Second is the necessary and useful expenses made on the things sold. In simple terms, he must return to the vendee a retro. So what must be returned? So, una, yun nga, the price. The vendor must return the original price paid by the buyer. So, the parties can come to an agreement to adjust this amount, but it must reflect the sale price, not the property's not the property's current value. So, second one is expenses of contract and other legitimate expense. Any legitimate expenses related to the sale, like the registration fees that the buyer paid, must be reimbursed. These don't have to be pay immediately though, so they can be settled later. So, third one is the um na necessary and useful expenses. These are two. So, yung necessary expenses are costs incurred to preserve the property. Example is to prevent waste, to prevent the damages. So, these ordinary maintenance costs are generally the buyer's responsibility, while the useful expenses, these are the improvements that increase the property's value. The vendor must repay this to the buyer, since the buyer is considered a good faith possessor of the property. So now let's take a look at the example that we got. So Alex sells a piece of land to David for 100,000 pesos with the right to repurchase within 1 year. Then time passes, Alex wants to repurchase the land but forgets to do it within the year. So the government takes the land from David due to a public project. So Alex pays the government 100,000 pesos to get the land back. So, the question is, can Alex claim the land back from David after paying the government? The answer is no. Alex cannot claim the land from David even though Alex paid the government. Um he still owes David the original 100,000 pesos to repurchase the land, since the right of repurchase requires paying the vendee directly. So that means Alex payment to the government does not fulfill that obligation. Alex also had the right to buy back the property, but the failure to do so within the time frame meant that David had legal ownership about it. So, and this article emphasizes that the vendor must repay the sale price to the buyer, and Alex's attempt to pay the government instead of David did not fulfill that. So, um, Now let's move here now let's move here, still part of Article 1616 or 1616, the mere declaration of one vendor of his intention to exercise the right of repurchase is not sufficient to preserve the right of redemption. The law requires that the offer must be a bona fide one, meaning genuine, sincere, and with honest intention, and must be accompanied by a tender payment. A tender payment is an offering the money. So, and accompanied by a tender payment or consignation. Consignation, on the other hand, is depositing the money in court for the full amount agreed upon for the repurchase. The buyer has clearly refused to return the property. The vendor is not required to tender payment. So this is based on the idea that the buyer has already declined. Any offer of payment would also be rejected. If the vendor attempts to tender payment after the right of after the right of the purchase has expired, the buyer's acceptance would only create a new sale agreement since the original right no longer exists. So now let's move forward to Article 1617. So this article talks about fruits during the redemption process or right of parties as the fruits of land. So you guys can read it na lang while I explain. And before I explain this thoroughly, we must keep in mind that this article applies only when the parties have not established a specific agreement regarding the sharing of fruits that exists at the time of redemption. So, and this article refers only to natural and industrial fruits. Examples of natural fruits, if you have forgotten, is crops and plants, while industrial fruits, on the other hand, are products derived from the land and there is a human intervention, like rice and corn. Civil fruits such as rent from a property are deemed to occur daily and belong to the buyer in that proportion. So now, going back, the law states that if there are fruits on the land at the time of sale and the buyer or the vendee paid for those fruits, the buyer must be reimbursed for the cost of the fruits when the vendor redeems the land. So this is because the payment for the fruits is considered part of the total purchase price. So if the buyer has already paid for the fruits, they are entitled to get the amount back when the vendor tries to reclaim the property. So, second is no indemnity for existing fruits. If there were fruits on the land at the time of sale, but the buyer did not pay for those fruits when the sale occurred, the vendor cannot ask for any reimbursement or for those fruits at the time of redemption. This means that if the buyer did not compensate for the fruits initially, they will not owe anything for those fruits when when the vendor tries to reclaim the land. Sim Simple as that. So the vendor did not pay for those, so he has no obligation to pay for them later. So third is fruits grown by redemption. If no fruits were present at the sale but some exist by the time the vendor wants to redeem the property, they will be divided based on the time each party possessed the land in the last year before redemption. For example, if the buyer owned the land for 6 months and the vendor owned it for 6 months, they would share the fruits equally. This sharing compensates the buyer for any expenses and effort incurred during their ownership. So now let's go to Article 1618. So Article 1618, the vendor who recovers the things sold shall receive it free from all charges or mortgages constituted by the vendee, but he shall respect the leases which the latter may have executed in good faith and in accordance with the custom of the place where the land is situated. So the vendor or seller who is redeeming the sold property does so free from any charges or mortgages from the buyer may have placed on it. This means that if the buyer took out loans or placed mortgages on the property, those do not affect the vendor upon redemption. The logic here is that when the vendor retro transfers the property to the vendee, the condition of the property should remain the same when the vendor redeems it. So any changes or mortgages placed by the vendee must be settled because the vendor is not responsible for those obligations. However, if the vendee has executed a lease in good faith, the vendor a retro must respect the lease. This means if the buyer rented out part of the property properly and in good faith, the vendor cannot simply disregard those leases upon reclaiming the property. With that, let's now go to section 2, legal redemption. So, if the conventional redemption is made or stipulated by the parties, legal redemption refers to the right to redeem the property that is established by the law. This means that even if the parties have a specific agreement about redemption, there are legal provisions that allow the vendor to reclaim the property under certain conditions, typically within a specific time or a specified time and following legal procedure. So Article 1619 provides that legal redemption is the right to be subrogated. By subrogation means transferring rights from one person to another, basically. So such as the purchase or dation in payment, where property is given in satisfaction of a debt. So this right allows the original owner, the vendor, to reclaim the property using the same terms and conditions outlined in the original contract. So here is the instances where there is a legal redemption. One, under the Civil Code, the instances of legal redemption are found in Articles 1620, 1621, 1622, 1634, and 1088. Number 2 is under special laws. The following are instances of legal redemption. So, A. Redemption by owner of real property sold for delinquent taxes. The period is within 1 year from the date of sale. If a property is sold due to unpaid taxes, the original owner has the right to redeem it within 1 year from the sale date. So, if a property owner fails to pay their taxes, the government can sell the property to recover the debt. That is known as a sale for delinquent taxes. So, in summary, if your property is sold because you didn't pay your taxes, you can get it back within 1 year by paying the owed amount. So, letter B, if a homesteader, someone who has settled on and improved the land, loses their property because it was sold under the Public Land Act, they have the right according to the law to repurchase it. Same with letter C. If a property is sold due to a court judgment like a foreclosure or debt collection, the original owner has the right to reclaim it. And also, we must take note that legal redemption is considered a privilege, meaning it's a special right granted to certain individuals, like the original property owner, to reclaim their property under specific conditions. This privilege exists partly due to public policy. The law aims to protect the individuals from losing their property unfairly, especially in situations like tax sales or judgments. It helps maintain the stability and fairness in property ownership. And that will be all for my part. Now let's proceed to Article 1620. Thank you.
Article 1620, a co-owner of a thing may exercise the right of redemption in case the shares of all the other co-owners or of any of them are sold to a third person. If the price of the alienation is grossly excessive, the redemptioner shall pay only a reasonable one. Should two or more co-owners desire to exercise the right of redemption, they may only do so in proportion to the share they may respectively have in the thing owned in common. This article highlights the right of legal redemption of co-ownership. Imagine you own a house with your siblings. You and your siblings were all co-owners, which means that you share ownership of the property, specifically of the house. Now, let's say one of your siblings decides to sell their share to someone, or what we call a third person. This article gives you as a co-owner a special right called the right of redemption. But what is the right of redemption? Well, the right of redemption allows you as a co-owner to redeem the share that is being sold to the third person. Meaning, instead of a third person being the buyer of the share, you as a co-owner have the rights or chance to be the one taking the place of being the buyer, so that it will gonna be you who are going to be the new owner of that share. However, when can we use our right in this article, or in what situations could it be? First, when any of your co-owners sells their share to a third person. Remember, even though it is only one of your co-owners selling their share, you already have the rights to buy back that share, and you don't have to wait for them all to sell their share so you can redeem it. One co-owner is enough. Second, pay at a reasonable price. For an instance that your co-owner sold his share for 1 million pesos, but the actual value only reached 600,000, you, as a redemptioner, only have to pay the reasonable price of 600,000. And third, if there are multiple co-owners that wants to have their right of redemption, they can do so proportionally. For example, you and your siblings wants to redeem a share that is being sold, by which you own 50% of the property, and your siblings on the other hand owns 50% as well. By using this article, you and your siblings can redeem the share in the same proportion. 50% will be yours, and another 50% will be for your siblings. Article 1621, the owners of adjoining lands shall also have the right of redemption when a piece of rural land, the area of which does not exceed 1 hectare, is alienated, unless the grantee does not own any rural land. This right is not applicable to adjacent land, which are separated by brooks, drains, ravines, roads, and other apparent servitudes for the benefit of other estates. If two or more adjoining owners desire to exercise the right of redemption at the same time, the owner of the adjoining land of smaller area shall be preferred, and should both lands have the same area, the one who first requested the redemption. Think of it like you being a landowner and that you have a neighbor selling his rural land to someone, or let's say a third party. In this case, this article will give you the right of legal redemption of adjacent owners of rural lands. For example, Jenny sells 0.8 hectares of rural land to Cindy, who is actually an owner of another property. Now, you own 0.2 hectares of that property. If you want to exercise your right of redemption, then you can do so, because under this article, you have all the rights to buy the 0.8 hectares all you want before the buyer could get it, because you own the small part of the property. Article 1622, whenever a piece of urban land which is so small and so situated that the major portion thereof cannot be used for any practical purpose within a reasonable time, having been bought merely for speculation, is about to be resold, the owner of any adjoining land has the right of preemption at a reasonable price. If the resale has been perfected, the owner of the adjoining land shall have a right of redemption also at a reasonable price. When two or more owners of adjoining land wish to exercise the right of preemption or redemption, the owner whose intended use of the land in question appears best justified shall be preferred. This article helps prevent land speculation through allowing neighboring landowners to buy urban lands that is being resold, and of course, at a reasonable price. Now, for an instance that there are multiple buyers who wants to get the property, the priority here will be the one who have best use for the land. For example, a neighbor Ferdinand wants to resell his lot. Now, Rose, Ferdinand's neighbor, decided to buy it to build a garden. On the other hand, another neighbor, Celine, also wants to buy it to build a storage. The law would likely be in favor of Rose since her intended use is best justified rather than Celine's. This article encourages buyers to use land for useful purposes. Article 1623, the right of legal preemption or redemption shall not be exercised except within 30 days from the notice in writing by the prospective vendor or by the vendor as the case may be. The deed of sale shall not be recorded in the registry of property unless accompanied by an affidavit of the vendor that he has given written notice thereof to all possible redemptioners. The right of redemption of co-owners excludes that of adjoining owners. This article helps to set rules to exercise the rights of preemption or redemption, by which potential buyers must be notified in writing with the right of redemption because proof of notice is required so that the buyer can finalize the purchase of land. Remember that co-owner is prioritized over the neighboring owners in cases that there are multiple potential buyers. Now, let's say Philip and Beth are owners of a land that is to be sold to Faith. Peter, their neighborhood, wants to exercise his right of redemption, but according to the article 1623, Philip and Beth's right as a co-owner overrides Peter's right as nearby landowner. Philip and Beth will be having 30 days to decide if they want to buy the property back from Faith after receiving the written notice. So yeah, that concludes our discussion for Chapter 7, Extinguishment of Sale. I hope you learned well.